A central part of creating any source code escrow arrangement is the determination of appropriate release triggers for the deposited escrow materials. That is, when should the source code escrow agent release the deposited materials to the beneficiary, to the licensee? Well, these are negotiated items, and I can tell you that they are not the same in every agreement, but there are some trends, there are some standards. You shouldn't content yourself necessarily with the templates that are provided by many of the popular escrow companies. They all have standard agreements and are happy to provide those to you, and they ordinarily contain a list of escrow triggers, but they may or may not be appropriate triggers in a given situation, in a given relationship between licensor and licensee. What are the appropriate triggers? Well, if you're the licensee, of course, you want a longer list and a broader description of the kinds of circumstances that would warrant release of escrow. And if you're a licensor, you'd like that list to be short and you'd like it to be quite detailed and specific. But the most common one that we talk about is often bankruptcy. Should the licensor enter into bankruptcy, is that an appropriate trigger for releasing the escrowed materials? From a licensee's perspective, the reason we've entered into an escrow relationship is because we want the ability to provide code maintenance and support for ourselves in the event that the licensor becomes unable to provide that support that we've purchased, that support for which we've contracted. And in order to provide that support for ourselves, we need the software source code. Should the licensor enter bankruptcy, we are placed into a circumstance of uneasiness and of worry that the licensor might become unavailable. Bear in mind that being part of bankruptcy alone, being in bankruptcy, does not mean that the licensor is necessarily unable to provide support. Should a company enter bankruptcy in the United States, a trustee will be appointed and the trustee will determine whether to affirm or to reject that maintenance contract. And if the trustee elects to affirm the contract, that is, if the company decides to continue performing its maintenance and support obligations, then one could argue that the licensee is no worse off. The fact that the licensor has entered bankruptcy is of no practical effect on the licensee. And so when I'm representing licensors, I often advocate against including the mere entrance into a bankrupt situation as an appropriate release trigger. We try to avoid that being a release trigger. As a licensee, though, because of the uneasiness created, I may desire to go ahead and have that be a release trigger, even if the company is continuing to perform support. One of the reasons is that even after release of escrowed materials, there will be some lag time. It will take my engineers some period of time to study the source code, to become very familiar with it, to get themselves into a position where they can provide the support. So even after the licensor has entered bankruptcy, even after there's been a release of source code, I need some time to learn. And so a licensee may well want to have that release of source code even while the licensor is continuing to provide support. Of course, a licensor would prefer to say, so long as I am continuing to provide what I've promised, you are no worse off. In fact, until I have ceased to provide what I've promised, until there has been a breach or an uncured breach, in fact, there should be no release of source code from escrow. So oftentimes I'll see as listed as a trigger in an escrow agreement that any breach of the maintenance and support agreement will constitute a trigger for release of source code. Now, I would argue almost every time that saying that any breach of the agreement is a release trigger is inappropriate. There are some releases that are just not relevant. For example, the licensor may have an obligation to provide certain reports periodically, or the licensor may have obligations to provide marketing data to a reseller licensee. And a failure to perform those duties, a breach of those obligations under the relevant contract, may be a hardship to the licensee, but it might not have any real bearing on the licensee's support of the software that it has in-licensed. And so any breach is probably too broad of a trigger. Instead, as licensor, I usually try to steer the argument towards saying that an uncured breach of the code maintenance obligations themselves is the really solitary appropriate trigger for release of the source code. And so, of course, you can see there is a difference in perspective from the licensor and licensee, but they certainly bear around whether or not support has been provided. That is, after all, the reason for having the source code escrow in the first place. I would encourage you to study carefully the release triggers that are listed in those template agreements that escrow companies might provide to you. They may or may not be appropriate, and you should always feel free to negotiate those and to edit those in those templates. After all, it's not really a concern to the escrow company. That's a matter between the licensor and the licensee, and so those can readily be adjusted to be appropriate for the particular relationship in hand.